Hi, and welcome to another edition of Dad's Divorce Live. I'm Matt Allen, editor of DadsDivorce.com. Today I'm joined in studio by Will Halaz, an attorney with Cordell Cordell, and we're going to be talking about modifications. Will wrote a series on modifications, basically outlining reasons for a modification, how to behave before your modification, how moving affects your modifications, and what evidence you need to prove that a modification is in order. So we'll be talking about those topics today. So first off, Will, could you review some reasons why someone would need to modify a court order?
Well, I guess the best way to start is with the standard. In order to modify your custody arrangement, you need to show a substantial and continuing change in circumstances. And what that means is not only does it have to be a big change, whether that be you losing your job or taking a severe pay cut or your spouse moving to another state, but it also has to be something that's going to be continuous and ongoing and not just a temporary loss of income, for example.
So how long after the original decree has been entered, what's a general rule of thumb of how long you should wait before filing a modification?
Well, it's going to vary from situation to situation. Typically, the court will look at about a 2-year period. But again, that's not a hard and fast rule, and that's something many people don't really understand, that you don't have to wait 2 years in order to modify.
But probably any modification requests within a couple weeks or months of decree is probably suspect at best.
Right. Typically it would be difficult because you have to show that change in circumstance from the time of the decree. So if nothing's changed since the decree, even if it was known before that time, then the judge is unlikely to modify.
Now, you mentioned a parent moving out of state. We get a lot of questions about how moving would affect parenting time or child custody. So how does one of the spouses moving affect modification?
Well, under laws that are active in most states, a parent has to inform the other parent if they're going to move, whether it's across town or out of state. Typically, courts want to let children have a consistent environment that they're in. It's good for their growth and development. So if someone's going to be moving out of town or out of state, then they're going to have to show that it's in the child's best interest to either move or to stay with whichever parent is requesting the modification.
So before you file your modification, obviously your behavior will go a long way. So how should people be acting during this process?
Absolutely. The judge is going to look not only at the behavior of the individual who wants to modify, but also the behavior of the individual who doesn't want the modification. Needless to say, I think you need to be on your best behavior. You also need to show that you're taking an active interest in your child's life as opposed to just trying to punish your former spouse or your child's other parent.
Now, finally, once modification you filed for the modification, you're going to have to prove what you allege is actually taking place. So what evidence do you need for a successful modification?
Well, it's going to depend on your reason for modification. If you've been spending a lot more time with your child than what's in your order, either by consent or because the other party just doesn't really care what's going on, then typically, we would like to see a calendar showing the amount of time that you've been spending. Third-party witnesses are also really helpful, especially teachers, coaches that see you, people that see you playing an active role in your child's life.
That's Will Halaz, an attorney with Cordell Cordell. You can read more about his articles on modifications on the DadsDivorce.com website. I'm Matt Allen, editor of DadsDivorce.com. We'll see you next time.